Right, that's it.
Okay, right, thank you. Good morning, everybody, and welcome to the pre-examination meeting in relation to the Falkirk Council Denny Eastern Access Road Compulsory Purchase Order. My name is Paul Coquette. I'm an inquiry reporter appointed to report in relation to the scheme and make findings, conclusions and recommendations based on the scheme proposed by Falkirk Council. We have 3 statutory objectors to the scheme and 1 non-statutory objector who have lodged objections in relation to the scheme, and the purpose of this meeting is to give consideration to certain procedural matters. As you all know, this is a procedural hearing in order to ensure that the steps taken in relation to the task with which I'm charged is carried out in an efficient way and an effective way to ensure a kind of clarity of focus in what we're doing and to ensure fair notice and a proper process to apply to give all parties, both the promoting authority and those objectors, a fair opportunity to understand the cases and the arguments and focus as much as we can to make the system and process as effective as possible. As you'll all know, this as a procedural hearing is not an opportunity to be addressing me or others in relation to detailed matters that will be the subject of the public inquiry in due course. But I'm conscious from some of the exchanges and having read the objections and the statement of case by Falkirk Council that there are a number of issues to discuss in the course of the meeting this morning. We have 2 hours set down. You'll have seen from the meeting invitation that the line is open for 4 hours. That's not an invitation to take 4 hours, but whereas I certainly hope we can get through our business in a faster time than that. But we do have a little bit of extra time beyond that if need be for dealing with matters. In terms of parties and agents here just now, I see we have another person who's joined us just now, but we have Jackie Maguire from Brodie's, I think, on behalf of Falkirk Council, supported by Douglas Blythe and Kevin Collins from the Council on behalf of the Promoting Authority. I have Alistair McKee of Anderson Strathern and Alistair Aikenhead representing the Calendar Trust.
Could I just pause there, sir? Sir, if I could just pause. Jason Hogg has just joined. Jason Hogg has just joined. He is also representing the trust. So representing the trust are myself, Alistair Aikenhead, and Jason Hogg.
Excellent. Thank you, Mr. McKee. That's very helpful. We have Alistair Sutherland representing Avant Homes, an objector in this. I think you've not got. I beg your pardon, you've got David Reid and Nicola Lunn with you today, your clients in support, and the third statutory objector is on behalf of John Taylor. Martin Hall is appearing here on behalf of Mr. Taylor. I've got just a couple of preliminary things before we get into the kind of detail of the discussion this morning, but I'd circulated an agenda on Wednesday which had incorporated some additional points, and I hope all the Alistair McKee's points that he'd raised at the beginning of the week are all incorporated into that agenda. But before I raise a couple of preliminary issues, I just wonder whether anybody has anything else that's not otherwise covered by the agenda that they would wish to deal with in the course of today.
I think we do, sir. We have corresponded with yourself in relation to the scope of the inquiry, in particular in relation to the matter of the alternative access, the planning considerations and accommodation works, etc. And I think it would be quite useful for the parties to have your views on those matters, if not today, in the due course of time, so that we're aware of the scope of the inquiry and the matters that you will be considering during the course of the inquiry.
Yes, indeed. I think that's fair. My intention is to look at those issues essentially starting with the basis of Falkirk Council's letter of 18th of March as item 5 on the agenda, and all the issues raised there and the responses received thus far, I think, are important to deal with there. That's an important issue, I think, to be clear on certain of the aspects of matters that are raised by you, Ms Maguire, on behalf of Falkirk Council. So yes, I think we'll endeavour to cover that as well. My preliminary issues, really just a couple of things. First of all is that letter of 18th March, Ms Maguire, that was indicated as no doubt is the usual form of letters from your firm as being confidential, and I'd be welcome your views as to whether you have any objection to that being published on the DPA website.
None at all.
Thank
None
you.
at all, sir. I think that's been, we've been queried about that already by your,
Right.
and we've said that's fine, it can be published.
Excellent. Well, that's fine, because that can allow Mr McKee's response to go, and the DPA, the agenda for today to go as well, because that those reference that. The second preliminary thing is for Mr Hall. I was conscious that that there was a bit of an administrative hiccup we had in communicating with your firm. I think one of your assistants or partners dealing with this matter on behalf of Mr Taylor had left, and whether it was DPA or whatever, I think there was a delay in communication with you. Hope that wasn't our fault, but nevertheless, I'm delighted that you've been able to become aware of today's meeting. The one thing that's outstanding from that, I think, is your statement of case, which obviously you didn't get the notice that we meant to give you or intended to give you because of that administrative email hiccup. But I think we're still awaiting your statement of case, Mr Hall, and I think we can proceed this morning, because I've read and familiarised myself again, reminded myself of the objection that your client has made. But it would be useful, as soon as reasonably practical after today, if you were to submit that and circulate it.
Yeah, the intention certainly is to do that, so I'll get onto that. Now that I'm aware of it, I'll get onto that and get that submitted.
Okay, I'm grateful. I'm grateful for that. And the last preliminary issue, just from my perspective, and I think this is just for clarification, is that we will talk a little bit on item 2 and beyond in the agenda this morning about the geographical area that's to be sought in the order. But I noted that in at least some of the original objections from last July, there were points made, I think on behalf of Avant Homes and the Trust, about certain inaccuracies about the tenancy arrangements that were in place and the schedule to the compulsory purchase order. And at that point, there were some errors that had been indicated, partly because of the passage of time, and I think it's one of the original tenants had deceased in the meantime. I'm assuming, for the purpose of this inquiry, because it hasn't been repeated in the statements of case, that at least as far as those represented here this morning are concerned, this matter is being effectively treated as being cured by your presence here. Any issues about defective service. If that's not the case, obviously I'd be quite keen to hear that. But given that those points made initially weren't repeated in the statements of case, it'd be useful to get clarification from parties whether they're maintaining an objection on that particular ground, or whether, as I say, we can assume that by appearance, at least your interest as in any issue of defect in service is now cured.
So if I could start, I can confirm that is the case. So.
Yep. Thank you. Okay. Anybody else? No,
yes, so and I can also confirm the same on behalf of Avant, that the basis for Avant's objection is restricted to the points that have been raised in the statement of case. So to the extent that the previous letter of objection raised other matters, those are not issues for inquiry.
Okay, that's very useful. Thank you for that. I'd say perhaps just to Falkirk Council, when we do get to the inquiry in due course, while that obviously resolves the issue as far as those who are able to have become aware and therefore appear today, it would be useful just at some point if we could just have that kind of reassurance that all service intimation requirements of the order affecting parties not represented today have been fully satisfied. And I appreciate that to a certain extent is proving a negative, but given the issues that have arisen, it'd be useful if for the purpose of my report I could provide assurance that there's nobody who's not represented here today who might be in that position. As far as information is concerned, obviously service and notice of an order of this nature is extremely important.
Council take those comments on board and make sure that those are attended to.
Okay, I'm grateful. Thank you for that. Okay, right.
Sir, could I maybe just come in with a preliminary point?
Of course.
Yeah, so, sir, I just want to emphasise on behalf of the trust that they are reluctant objectors to this Compulsory Purchase Order 1 and Compulsory Purchase Order 2 when it is promoted. The trust support the scheme and would very much prefer to have entered or to still enter into voluntary agreements with the council. As recently as the 17th of March, we did receive an email from the council stating that they remain committed to negotiating the voluntary acquisition of the land. So what we really have here, and I think rarely in my experience do we have the three principal parties, and when I say principal parties, I'm referring to the trust, the council and Avan, whose interests are more aligned. I think we all want the road to be delivered as quickly as possible. I think the reason parties are objecting and the reason there may have to be a further process is to enable, shall we say, some of the obstacles that the trust and perhaps Avan are perceiving to be aired. I certainly would like to hear from the council that they are committed to continuing a parallel negotiation strategy along with the more formal compulsory purchase strategy in the hope that matters can be concluded, perhaps voluntarily or by basis of the trust in this instance, perhaps withdrawing its objection if it can be satisfied with the matters set out in its objection and statement of case.
Okay, thank you. Before I bring in the council, I wonder if Mr. Sutherland and Mr. Hall have anything they want to say on that particular aspect, then I'll bring in Jackie McGuire.
Thank you, sir. Just on behalf of Avant, I think we take it as given that the council is prepared to continue to have voluntary discussions in relation to this matter. So, whilst I think it would be good for the council to confirm that, we do not just hope that is the case, but indeed we would have the expectation that is indeed the case. And certainly in the same way as Mr. McKee on behalf of the trust has said that there are matters which have compelled the trust to object to the confirmation of the order, that is very much Avant's position as well, that they would prefer not to be having to object to the confirmation of the order, but feel compelled to do so because of the situation they find themselves in. But in terms of seeking confirmation from the council, we do take it as given that they will continue to have discussions in parallel with the compulsory purchase process.
Okay, thank you. Mr. Hall?
So if I can come in and confirm very much the same basis that we would be expecting and hoping that discussions would continue in parallel and that objection could be lifted if we reach agreement.
Thank you. Ms. McGuire?
I think it goes without saying, sir, that none of the parties in the room are keen to see this process progress any further than it has to. The reasons why the council is pursuing the compulsory purchase order are due to the criticality of the road's infrastructure for the reasons set out in the statement of case. The council is committed to continue to negotiate with the parties. Whether or not we can actually reach a negotiated settlement has yet to be seen, and for that reason, given the importance of the scheme to the council, it does intend to continue with the compulsory purchase procedure in parallel with voluntary negotiations. Beyond that, we can't say. It will depend on whether or not we can untangle the issues of the planning applications that have been lodged, developer contributions, etc., from the discussions on the voluntary acquisition.
Okay,
There is a commitment to try to find a resolution.
Thank you. I'm grateful to all parties for that. We may come back to that later on when we look under item 7 on the length of the PLI and the topics that are truly in dispute in all of this. I'm hoping we can touch on some of that in part of later discussion. So thank you. Thank you to you all for that. So item 1 is the need acknowledged by Falkirk Council for a second CPO in relation to the additional requisite land. And I'll maybe just invite Ms Maguire to just set out the circumstances of that to allow us to get a full understanding of what that could potentially mean and what that means for the interaction in practical and timings terms in relation to that. And when I go around parties after hearing from the council, I'll go to Mr Hall first of all, because the letter of objection last year, which dealt with a number of issues, some of which appear to be around questions of financial matters. There was a key issue in relation to, I think, Mr Taylor's objection was around plot 2, and that was the one I think that is most clearly affected by the potential second CPO. So I'll come to Mr Hall second, but Ms Maguire first.
I think that the circumstances that have given rise to the need for a second compulsory purchase have been fully explained in the Council's statement of case and in the accompanying letter. I don't know if the parties wish us to rehearse that again, but the Council is concerned that the range of powers that have been referred to in the compulsory purchase order are insufficient to enable the Council to acquire all of the land that's required to implement this section of the DAER in accordance with the planning permission that's been granted by the Council. In simple terms, the reason for that is part of what is required in terms of land take is required for a buffer zone to mitigate the impact of the road on the surrounding countryside. The Council hasn't included the powers that are required to enable that acquisition in the current compulsory purchase order, and it's not possible simply to amend that order now to include those additional powers. And for that reason, the Council has given very careful consideration to the need to promote the additional CPO. It's not possible to complete the DAER in accordance with the planning permission without that land being included, because the buffer zone is required under the planning permission. And for that reason, the Council proposes to promote a second CPO. The Council is hopeful that the promotion of the second compulsory purchase order is the most effective and efficient way to deal with this, if you like, virus deficiency. There is some hope that perhaps the process with the second compulsory purchase order will be allowed to catch up with the first compulsory purchase order, and that both orders could be considered during the course of a conjoined inquiry, as that would seem to be the most efficient and effective way, most cost effective way indeed, of dealing with it in respect of all of the parties. The Council doesn't tend to hang around in relation to the promotion of the second compulsory purchase order. Work has been undertaken in terms of the drafting of the order, the preparation of the plan. I think I've already shared a copy of what the plan will look like, certainly not with Mr Hall as yet because of the glitches we're aware of. But the parties are aware of the land that would be included within the second compulsory purchase order and have circulated a plan showing what the plan attached to the first order would look like as a consequence of the second order. The proposal is that the first advertisement of the second compulsory purchase order will take place on the 1st of April 2021, which will set in train the objection period. The objection period is normally 21 days, but the Council is extending that to 28 days because of the current COVID pandemic and the ability of parties to speak to advisors, etc. It's not anticipated that the second compulsory purchase order is likely to attract a wider body of interest than the first. However, the Council recognises that that is a possibility. For these reasons, the Council will communicate in advance with Transport Scotland to ensure that relevant officers are aware of the promotion of the second CPO and the interrelationship between the two orders, which might help smooth the process with Transport Scotland. The Council will also be in touch with Mr Jack, the non-statutory objector, in advance to explain the reason why the second compulsory purchase order is to be promoted, and so that he's aware it's not raising a whole range of different issues to those that he's been concerned about in the past. What the Council will try to do is move things on as quickly as it can and to keep parties, including yourself, advised of the progress that's made with the order as the procedure rolls out. we can talk, if you like, about, you know, things like other procedural meetings, etc. But that's a brief summary of where we have got to, the reasons for it, and the steps that have been taken already by the council to try and progress this second order.
Yeah, and is it at all possible? I know there's a lot of uncertainties with any promotion of any order of this nature. To give any kind of rough sort of timescale by which, if you like, that going down this track, the second order could catch up with the first one. That may not be the same.
Well, there's certain elements of this which are within the council's control in terms of putting the adverts out, notifying the parties, etc. And we would hope that the parties themselves, given that we're all on the same page and all want things to progress, would respond fairly quickly to the second order. It's for them to decide on what basis they want to object to the second order, if that's what they want to do. But we would imagine that by and large the objections are likely to look the same as they are at the moment. The bits that are kind of out with the control of the council are the period from which the matters in the hand of Transport Scotland, and how quickly, for example, they will deal with the interaction between the objectors and the council. So responses to objections going from the council, you know, back to objectors, that type of thing. And thereafter, once we've completed that process, how quickly they're then able to send it to DP. And we noted for the first order there was a bit of a delay between the first order being sent to DP on the 21st of October and you being appointed as a reporter, sir, on the 11th of December. But we would hope that, given that the first order has been allocated and that both orders being intrinsically linked, that period might be foreshortened. So that being the case, we would think if there was a requirement for a further pre-examination meeting, that might be able to take place mid-July going into August. If, and when, I know there's yet to be a discussion on procedure, matters were to be covered in the course of a hearing and no significant issues had to be considered, it may be possible to hold a hearing during the month of August, but towards the end of that month. If we had a full-blown inquiry into any aspects, any of the objections, I think that would take things into September. My clients tell me, although I think this is a bit optimistic, that not too many of them plan to be on holiday. But I think it's important to carve out the summer holiday period, the school holiday period, and people will undoubtedly come under pressure to take some time off work, and undoubtedly will want some time off work once the weather improves. But the council is committed to looking at and blocking out dates in advance in the latter part of August and into September. So there will be a bit of a delay, but I mean, I don't think it is that significant. It's that front end of it that you're kind of adding on to where we are at the moment.
Okay, right, thank you. Mr. Hall, next, on your thoughts on this. And again, I'm particularly interested because plot 2 it was the subject matter of your client's objection, and I'm interested in the extent to which the area that the council now require to promote an order for the additional requisite land is or overlaps, to the extent to which it overlaps with the objection to this order. So whether it's all the plot 2 that goes to the second order, or whether your client has an interest in both. But generally, as I say, I'd go to you first.
So for me, I haven't seen a plan yet of compulsory purchase 2, so I'm at a disadvantage from everyone else, I think. So it's difficult to comment. You know, the comments within compulsory purchase 1 relating to the width of the buffer strip, from I think the difference between 5 meters and 20 meters. So it relates to the effectively the land take on what is a very constrained unit already.
Okay. I wonder if it would assist Mr. Coquette to reassure Mr. Hall. We will get the copies of the plans to you as soon as possible. There's no additional land take proposed in relation to CPO number 2. I appreciate you may still want to maintain your objection in relation to the full width of plot 2, but there's no additional land take as a result of the second CPO. It's to the extent it's contained within the first at the moment.
Yes, that was certainly my reading of the plans, but it's useful to get that clarification for assurance to Mr. Taylor. I mean, I guess my question is Mr. Hall and indeed to other objectors' agents what their view is as to what the council's proposal about the conjoining of the inquiries and a consequential, hopefully relatively modest delay before we move to a full PLI.
So from my point of view, I have no objection to the joining up of the two orders and progressing them together if that's the quickest way to deal with it.
Okay, thank you, Mr. Sutherland.
No objection in principle, sir, but just obviously concerned about the potential for unnecessary delay here in any part of the process. And I mean, I think we're waiting until mid-July for a further pre-examination meeting and then hearing and inquiry in August, September. I mean, that really would have to be the absolute latest for when this conjoined inquiry would be dealt with. So I think we would certainly, and actually I should say, subject to actually seeing what the order says, you know, we would not be looking to try and take advantage of that to try and expand or complicate matters, but equally, I think we were looking for the Council, Transport Scotland, and indeed the reporters unit, sir, to make every effort possible to push things on without any unnecessary delay whatsoever. And that goes really goes back to the point that Mr. McKee made at the beginning, and that I endorsed, that you know we are somewhat reluctant objectors, and we want this to be sorted out one way or another, and we don't want this to be cause for matters simply drifting either the formal process or negotiations.
Okay, thank you, Mr. Leakey.
Thank you, sir. The Trust do not oppose the strategy suggested by Jackie Maguire, and I would simply like to be associated with the comments made by Mr. Sutherland sooner rather than later.
Okay, thank you. And certainly I will ensure administratively within DPA that by proceeding on that basis, we can try to encourage Transport Scotland to align the communications with us and the appointment process, since it makes, I think, makes obvious sense for me to be appointed to deal with both together to minimise that delay. In thinking about the preparation for this meeting, I too was aware, as Ms Maguire points out, that the summer season will be upon us, and few of us will be off to sunny climes in July, though many of us may be able to get some leave. I was turning over in my mind having a further business meeting towards the end of June before we get into that season. But if parties are happy to wait till effectively the kind of schools are back around the kind of middle of August, I'm equally happy to look to that period, if that can allow us then to start thinking about if there is going to be a public inquiry, looking to have one in September, perhaps October.
So my preference would be to have that business meeting in June rather than sort of bring it into beyond the long grass of the summer lockdown holiday. So that would be my preference.
I think there would be a measure of sense in that, because if the principal parties are maintaining their objections, we will know that by then, and we will also know whether or not there are any other objectors have thrown their hat into the ring, and you know what it is we have to deal with. But if we are essentially dealing with the same people, the same parties who are in the room at the moment, then we should be able to make some progress in terms of dates, etc.
Solomon, Mr. Hall, any thoughts on that?
Thank you, sir. Yes, no, I would wholeheartedly agree with that. I mean, because presumably we'd be postponing fixing dates for exchange of hearing and or inquiry reports until that further business meeting. So,
sure.
So there will inevitably then be a minimum period between the date of that meeting and whenever the hearing or inquiry sessions can take place. So the earlier, I mean, that business meeting really should be taking place on the first possible day that it can. So I would say June at the latest, or however earlier it can be achieved.
Okay, and Mr. Hall? Oh, I think you're on mute, Mr. Hall.
Yes, likewise. Thank you.
Okay, that's fine. Well, what I'll be do is try to explore dates that are convenient around that sort of sort of timescale. I mean, there's an advantage to me in that by then, as Ms. Maguire points out, we will have a clearer idea, both in relation to the position of the current objectors once they've seen and taken instructions on the second CPO, but we'll also know whether there is anybody else that has to be factored in, and if there are other parties that require to be factored in who come as a result of that second CPO, then the sooner they are brought into a PEM meeting process, the better. So I'll proceed on that basis for a further business meeting. There's quite a lot of other stuff we still can usefully utilise this time to address, so I suggest that we continue to do so as far as we can, standing all of that. And the next issue is the question of the clarification of the plots that are to be acquired and those that are not to be acquired, and how that's taken forward. And it might be that item 2 is a convenient place to address any issues I think Mr. McKee has raised in relation to temporary acquisition, if insofar as relevant for the purpose of this procedural meeting. So I'd suggest that any points arise in that respect. I suppose there's two things in relation to the plots. The first of which is just clarification of what plots are now intended to be proposed for the scheme, and the second is what the process is, whether it be my report or whatever, for the removal of plots that are now no longer being proceeded with. I think we've heard a little bit about the buffer zone around at least part of plot 2. From my reading of the papers, plots 4 and plot 9 are not to be proceeded with. And I saw Mr. McKee had referenced plots 7 and 8 to be removed as well. I've not seen that formally, but I'm assuming that the thinking is that plot 7 and plot 8 would fall because of the change to plot 2. But I don't know, I'm not certain about that. But perhaps, Ms. Maguire, you can clarify the council's position in both those respects, or all those respects.
Yes, there will be a change to plot 2. The dimensions of plot 2 will change, and we have a plan. It was, I don't know if you have seen that. Sorry, it was sent on, but only yesterday to your office. So that will. The breadth of that will essentially change to reflect the piece of land that will be in the buffer zone, in as much as plot, and I just have to bring it up on my screen, as my clients will tell you, I've been getting these wrong all along, in terms of numbers. So plot 9, which was the large plot at the northern end, which was required solely for the purposes of accommodation works, will drop out.
Oh, yes.
You are correct, but plots 7 and 8, this has been the subject of recent discussions. Those two are only required for accommodation works, and the council sees no need to retain these for that purpose within the compulsory purchase order. So the suggestion is that these two will drop out and a plan will be prepared. It will show these plots removed. The removal of the plots has nothing to do with the second order. It's just on reflection. We don't see the need to acquire land for accommodation works.
Sure.
If you just bear with me to catch up with
the others. Yeah, no, so take your time.
I think it just sits out there. Bear with me, it was in the letter that I sent to you, but I don't actually have it on my desk at the moment. Yeah. Plots 1 and 2 are for the new road. Plots 3 and 6 are temporary acquisition, but the plan is to remove 7, 8 and 9 from the CPO.
Right, okay. Yeah. And what's the formal process for doing that? Is that something that was the agreement of you and the acquisition of acquisitions of parties that I contain in my report that recommends those are not proceeded with?
It's not unusual for this sort of thing to happen as compulsory purchase orders are discussed, and even up into the last minute during the inquiry process. But the council has no requirement for these plots. They are required only for accommodation works, and we're trying to, obviously, we'll come on to that subject later, and negotiate with parties in relation to accommodation works. But if the accommodation works are to be carried out, we will need access to the land. So it makes sense to just have discussions with the landowners to provide that access to those works to be carried out. But there's really no justification for retaining them within the order. We would be planning to present you with a different plan, and it'll simply confirm that we are no longer requiring those plots to be included, and it's my view that if the council doesn't require the plots and has no justification for them, then they ought not to be included, and that ought to be reflected in your report. And if ultimately you do recommend confirmation of the compulsory purchase order, it would be with the exclusion of those plots.
Okay, thank you. I'll go to Mr. McKee next, because I think it was you who'd raised the question about the kind of the process for practically proceeding with the question of plots no longer required. So, comments, Mr. McKee first.
Thank you, sir. In the usual way to handle the sort of removal of plots 7, 8, and 9, which we're now told are no longer required, I think what we would be looking for is some written formal request or invitation to you, sir, to exclude these from the CPO, and that for that to be announced in your recommendation to ministers. And I think other parties, in particular the trust, and obviously I don't speak for the tenant farmer, but they would then say that they've read that and understood it and concur with that, and you would just have that correspondence, sir, and that would normally form, well, it could form sufficient comfort that those plots are being dropped. I can see in no way that the ministers would want to reactivate them if there was no justification for them.
Okay, thank you. Mr. Solomon?
Thank you, sir. I have nothing further to add in relation to that. It sounds perfectly sensible.
Okay, and Mr. Hall?
Yeah, I'll concur with Mr. McKee's comments.
Okay, thank you. Now, Mr. McKee.
Just before we go there, so I think the step following that, sir, is for the council to formally write to you about that, and for parties to be copied in, so we can see that action point being sort of addressed formally.
Yeah. I think that would be useful. As I say, I mean, I'm conscious that there are understandably discussions that are ongoing at any time, and as all parties have indicated, properly so. So it would be useful just to get that kind of effectively for the record. I'm grateful to Ms. Aguirre for confirming that the removal of plot 7 and 8 was something I took from Mr. McKee's letter, but I hadn't formally seen from the council. So I think that would be a valuable thing just to indicate, so that it's on the record at the earliest feasible stage.
We'll provide you with written confirmation of that in early course. You should have it at the beginning of next week.
That's fantastic.
Good.
Okay, grateful for that. Now, mindful that substantive matters are for later, but nevertheless, there have been some issues that have arisen, I think, in relation to the question of temporary acquisition raised by objectors, Mr. McKee principally. Others will have views on that as well. There may be something that we can discuss today about the extent to which, when we get to a PLI, this is an issue that we can focus on the precise nature of the questions that I'll be expected to see evidence on. But Mr. McKee, I don't know if you want to say something at this stage. I have an issue I'll mention maybe at the end in relation to the acquisition of the accommodation work sites. But I think, Mr. McKee, you'd raised the point about temporary acquisition. I don't know if you wanted to say something just now for the purpose of this meeting.
Yes, sir, certainly. The temporary acquisition plots, just to recap, are plots 3 to 6 inclusive. The trust position is really that they remain uncertain and concerned about the council's intended approach for the acquisition of these temporary plots, because the council are seeking to use, through the order, permanent acquisition, when truly their purpose is only to acquire these temporarily, to simply temporarily possess them. Now, I understand that arises from an interpretation of the Road Scotland Act, and it's really a varies issue. And the council have indicated that they have sought the advice of Transport Scotland on that point, who have confirmed that the only way forward, if temporary plots are to be acquired compulsorily is through the permanent acquisition process, because temporary possession is not allowed. I did put in a request to see that advice. I thought that'd be quite helpful for us to see that. I mean, to encapsulate what the Trust's concern is, if the council are intent on using permanent acquisition for a temporary purpose, and the ministers are prepared to allow that to happen, the issue for the Trust is that how do we control the return of the land back to the Trust once the accommodation works have been completed? The council have made some reference to Critchell Down rules, which, you know, take you so far, but they don't really provide the comfort that the Trust requires here. To give you an example, the way in which such thing would normally be done for temporary acquisition would be, you know, temporary acquisition in the voluntary sense would be through a license. That license would obviously allow access to be taken, works to be taken, but it would record the condition of the land. It would then require, when the promoting authority left the land, for the land to be restored back to a reasonable standard. There would be, you know, a payment made for the exercise of that license, and there would be certainty about it coming back. The issue we have here is, if the CPO takes place, the Trust will no longer own the land, so it will be seeking almost a conveyance back from Falkirk Council. It's just a bit clunky and it's a bit clumsy, and the way in which I thought that, should we say, the risk could be resolved on the part of the Trust about the return of the land is that the Trust and the Council, before the CPO is confirmed or otherwise, enter into a contractual arrangement which covers the matters I've discussed, such as when access is going to be taken, the condition of the land, and the certainty about the return of title back to the council at a certain price as well. Because if the Trust allow the land to be CPO'd, it's lost control of the issue, and there's no way of compelling the council to give it back. That's the sort of the nub of the matter. There have been discussions, I think, possibly historically, around about a licensing arrangement, and, you know, perfectly happy to continue that discussion with the council. But that's really the concern, and it really arises from the council seeking to use perhaps the only mechanism it has for compulsory purchase, which really isn't fit for this particular purpose, which is temporary possession. But I'll maybe just pause there. I mean, maybe Jackie Maguire wishes to address you, sir.
Sure. I'll bring in Mr. Hall and Mr. Sutherland, then go to Ms. Maguire.
Okay.
Mr. Hall.
Thank you, sir. Yeah, we equally have a problem with it. It would extinguish any tenancy rights that exist over that land. So our client's interest would be extinguished at that point, and with no mechanism to reinstate that should it be required. Our experience of the temporary possession on other schemes is that it is a very long process, like 10+ years after the scheme is opened, before the Transport Scotland will even entertain a discussion, and it is a really hard work to get these plots returned, and it's not guaranteed in any form. So we would share Mr. McKee's concerns.
Okay, thank you. Mr. Sutherland.
Thank you, sir. Just really just endorse what Mr. McKee was saying, and that I think it would be very sensible to have some kind of contractual mechanism to bridge the gap between the compulsory purchase and the Critchell Down rules, which themselves don't actually provide any obligation on the acquiring authority to return surplus land. So, which is presumably what the authority is saying this land would be at the end of the period of temporary occupation. So, if they know that it's going to be surplus land at that point, then I think it would be in the interest of good order to have something in place actually that would then oblige them to return it at the end of that period of occupation. And as Mr. McKee was saying, the precise terms on which the land would be returned.
Okay, thank you. I mentioned at the start of this bit of the discussion, I had one question in my mind. I'll just maybe plant that as something that is something I think I'd like to hear about, not necessarily now, but at the inquiry if needs to be, when we discuss this substantively on this particular point, is that question of what seemed to me from the papers I've read is a little bit of an uncertainty as the full extent of how much of the work of the land that would be taken for this purpose would then fall to be returned. And I think the council have indicated that and indeed may say in a second, that it's not possible in advance to definitely say with certainty how much is to be returned. But there's a wee issue there from my perspective that might be useful when we get to the inquiry, just to hear a little bit from the council about how you ascertain the geographical extent, because that's one of the issues for me in looking at the justification of the scheme, is a full justification for the taking of all the land that's sought. But that's perhaps getting on ahead a little bit, and as well, I shouldn't feel constrained to answer that just now, because this is a procedural hearing. But certainly any comments on the points raised by objectors would be very useful.
I don't think that I do feel that constrained about answering that point.
Yep. Okay.
So we can,
That's fine.
first of all, I think we have to be quite clear here that the council is not relying on the Critchell Down rules in relation to the return of the land that's required for the purposes of construction purposes for the road. So those temporary land take. The Critchell Down rules will apply where we're looking at surplus land, so land that might be taken for the road scheme that isn't actually ultimately required for the road scheme. These plots are being acquired for the purposes of things like storage, facilities, etc., that are necessary during the construction phase. Once the construction phase has been completed, the council will have no requirement for this land. So it's not a case of the land might be surplus because it's not needed for the roads infrastructure. The land is only required for a very specific purpose, which is during the construction phase. And once that construction phase is getting completed, allowing perhaps, and this would be perhaps subject to some discussion, whether or not some of the land might be required for just a bit longer during a defects liability period, for example, but that would be part of the construction phase. Once that has been completed, the council's intention is to return those plots, and those plots are quite clearly defined on the plans. They're not something that's nebulous and is within, for example, the perimeters of plot 2. They are clearly defined on the plan, and it's those areas that would be returned to the landowners. The council has also said, and it says quite clearly in its statement of case, that it is willing to provide the landowner with an undertaking to the effect that the land will be returned once the construction phase has been concluded, and that undertaking will include a long stop date for the return of the land in question. And that long stop date would be ascertained looking at the length of time it would take to complete the construction process, including where appropriate any defects liability period. So there would be a long stop date in place. It would be nothing like 10 years. And we'd be looking at the construction period for the road and perhaps a small period of time thereafter for defects liability in case access was required for that purpose. So we're not relying on the Critchell Down rules. The plots are clearly defined. It is a question of handing back. We would be delighted if we could negotiate and conclude licence agreements with the landowner. That would be ideal. And as Mr McKee says, the usual matters would be included in there, including returning the plots to their precondition, if you like. But the plots are required for the purposes of constructing the road, and the council can't rule out the possibility that it's not possible to conclude licence agreements, and for that reason would like to proceed with the reports remaining in the order land. But to be quite clear, it's not a Critchell Downs situation. They are quite clearly defined, and the council is quite willing to give an undertaking. It's also quite possible for you, sir, to make a recommendation that the council is enabled to acquire the plots on a compulsory basis, subject to the condition that by that long stop date, the plots are returned in their entirety to the landowners.
Okay, thank you.
Yeah.
I don't know if anybody wants to respond, Ms. Bickey.
So thank you, and thank you, Jackie, for that. That is helpful and takes us quite the way there in terms of the mechanism. I think the issue for the trust is really just the timing of the commitment. I mean, that is what concerns the trust. I think it might suit the council to, shall we say, backload that commitment. I think the trust would like to front load it, and I think if you were making recommendations to ministers on the, you know, on whether or not these temporary plots should be recommended for the CPO, then I think you should really be making that on the basis that parties have entered into a license, and that license can deal with two things. It can still allow the CPO to take place, but it just allows the trust to rely contractually on compulsion for the return of the land within the parameters. We're not trying to make it difficult, sir. We're not trying to sort of say you can only have it for half the period. You can have the land for as long as you need it for accommodation works and use it for whatever purpose, provided we have the advance certainty that a contract would bring about that return of the land in a reasonable condition, etc. That's all we're seeking.
Right, excuse me. That's very helpful. I mean, that's a useful airing of the issues that will require, no doubt, to be taken forward in the period prior to the inquiry itself. That are matters not directly for me. Clearly, of course, the nature of a compulsory purchase order, if the Falkirk Council's case is made, is in the circumstances where, you know, what would happen if an agreement isn't reached. So, you know, I recognise the shared desire to reach an agreement, but compulsory purchase powers are there in the event agreement isn't reached, and that's what I need to report on the basis of. So that clearly is a factor that I'll require to take into account, and I recognise the kind of chicken and egg dimension of this as well, in the steps that will be taken between now and the PLI to try to ensure that agreement is in place. Obviously, if it isn't in place, I'll need to listen to parties and consider what that means for the recommendation based, as Ms. Aguirre says, on whether the acquisition of the land can be said to be justified. But that's been a very useful run round those issues, and I think allows a kind of focus, certainly from my point of view, hopefully allow clarity in the event of agreement isn't reached on the basis of temporary acquisition of the issues that I'll be addressing during the inquiry.
If it helps, sir, I mean,
sure.
Closer to the time, the council can prepare an indicative outline of what the programme is likely to look like and what the long stay is likely to be. Yeah, I think that'd be useful. Okay, thank you. I think I can move on to item 3 in the agenda. I know Mr. Jack, the non-statutory objector, who, in respect of this relates, is not attending the meeting this morning. I'm not anticipating his participation in any further part, and his reliance on his written objection. I think ahead of this meeting, I'd given a general indication of my initial view that I didn't think that the his objection, which was contained and amplified by an email a few weeks ago, I mean, it did refer not so much to proposing an alternative route, but it was referencing a suggestion that the route ought to be further away from Denny High School, which is pretty close to saying that, but isn't quite saying that. Mr. Jack has not come back, and obviously isn't at this meeting to speak for himself. I think I nevertheless remain of the view that he is really effectively only barely saying that the road should be on a different line. I've seen his objections, and we'll come later on perhaps to the sort of things we'll expect to hear from Falkirk Council about the extent to which air quality issues within the vicinity for the school and elsewhere, and road safety, etc., have been taken into account. But I think my view remains that there's no issue under Rule 6. I don't think he's not certainly suggesting that, and I'm still inclined not to say that we're into Rule 6 territory, which would require the ascertainment of an alternative line for consideration for this order. And I presume certainly the council wouldn't object to that view. No, the council doesn't have any issue at all with your view on that matter. We raised the matter of Rule 6 simply clarify whether or not you envisage that any further procedural steps are required in relation to Mr. Jack's objection. We've also had a look at mapping out what that alternative route might look like, and I mean, it is quite clear that the rerouting will simply re-engage the parties who are already parties to this process. It's unlikely to involve any other affected parties. I just wanted to touch on one thing with regards to Mr. Jack's submission. He doesn't, it appears, intend to participate in any further oral proceedings. On that basis, the council was hopeful that you would be satisfied with the council responding to his objection by means of written submissions. It will, of course, as you've requested, address all the matters that have been raised in his initial objection and the points he also made in his email to you of the 26th of January this year, including air quality and road safety. But as he's not going to be there or not engaging in oral proceedings, it seems that would be the most effective way of dealing with it.
Yeah, thank you. I mean, unless other parties represented here today would wish to engage in discussion in that respect, I would say that would be a sensible way forward. As I say, if the submissions really address what I think are the appropriate aspects of Mr. Jack's objections that I can consider, namely whether the specific consideration in relation to air quality has been assessed, and I think that's effectively what you've been saying on behalf of the council, in relation to air quality standards, and it meets the requirements of that, then I'd be content to receive evidence on that basis of that written submission.
That's very helpful. Early discussions with the council indicate that we will receive a fulsome response on those points.
Excellent. That'd be very helpful. I think that's important from Mr. Jack's perspective, that his concerns are both wide-ranging but also narrowly and specifically focused on this issue. It's not an unreasonable question, and it has been an issue of contention in a number of other areas. But obviously, I'm dealing with a scheme before me, and I need to address that scheme. Okay.
Right, so just for the record, sir, the Trust are content with your ruling that Rule 6 is not engaged.
Okay, thank you, Mr. McKee. I'm grateful for that. Item 4 we've dealt with already, of looking at a date for a further business meeting, and then moving on to item 5. Items 5, 6 and 7 to a certain extent, I suspect, may to a degree overlap with each other. But I'll try and separate them out as much as I reasonably can. I mean, this issue really relates to a number of things within the kind of scope of my remit and what I'll be addressing. I think everyone here at this meeting will understand that the remit I have does not relate to compensation issues or land values. I certainly think it can be readily understood that my role here will not relate to the merits of the planning application or in negotiation matters in question developer contributions. So there are limitations on what I'll be looking at. But I'll maybe ask Ms Maguire to speak to her letter of 18th March, which raises a number of issues in relation to accommodation works, funding and planning permission and technical information, and then take views from others with a view to looking at the kind of focus and dealing with her suggestions about what may be out with remit. So Ms Maguire, first of all.
Okay, so in relation to accommodation works, I mean, we have had regard to the Trust statement of case, and it's clarified that the basis for objecting in relation to accommodation works is that these matters ought to be the subject of a binding legal agreement. And in our letter of the 18th of March, clearly we question the competency of that ground of objection. It's the Council's submission that accommodation works are essentially a matter of compensation, and indeed where accommodation works are not provided, that may give rise to an entitlement to monetary compensation. So in our view, accommodation works are items of capital expenditure or investment which mitigate the level of financial compensation to the affected party. We agree it's preferable to reach an agreement where possible in advance of the promotion of a CPO, but on occasion that's not possible because of the level of the detailed design has reached, and the finer detail can't be agreed. We do note Mr McKee's response, and we agree that it is commonplace to negotiate and agree common works in connection with road schemes. Well, of course it is, it happens all the time. The council position doesn't contradict that. However, the council's position is it's not commonplace to take forward such matters, which are essentially matters relating to compensation in kind, and it's not commonplace to include them within the scope of public inquiries in relation to compulsory purchase on roads infrastructure scheme, or to delay the progress that's made with a compulsory purchase order until such matters have been resolved in binding agreements. Council very committed to continue discussions. As I understand it, there have been some useful discussions with tenant farmer in relation to accommodation works, and the council will continue with those. But in our view, these are not matters that can competently or appropriately be considered during the course of an inquiry. If we're looking at other roads promoters, for example, Transport Scotland being the most obvious because they're the ones who engage in this type of project most often, their standard position is that they will not discuss accommodation works during the course of inquiries, and that doesn't seem to be something that is routinely pushed back on or ground given in relation to that, and reporters being content to read on that basis.
Okay, thank you. Mr McKee?
Yes, sir. All those points are noted, and obviously I have responded with my email of the 19th on that point. To be quite honest, sir, I think all the trust are looking for here is comfort and a degree of confidence that the scheme will be delivered with, what one would expect to be the normal mitigation. Now, these are farms. They have livestock on them. There's horses, cattle, etc. And they're businesses. And I think that the trust and indeed the tenant farmer is entitled to see in advance. If it's not to be a binding contract, then what sort of fences are we talking about? Who's going to build those fences? What's the expectation? What about issues such as drainage and the like? These I agree, are often backloaded, but backloaded often to the detriment of the landowners and the agricultural tenants, in a sense that they're left to the last minute. And, on many occasions, the accommodation works are not delivered satisfactorily. And I don't think it's a sort of case you can simply say it's accommodation works or compensation. So what we're really dealing with here is compensation and is not within your remit. What we are dealing with here is, I think, is sensible mitigations that one would ordinarily expect in a major road scheme such as this. And I am pushing here for a binding contract, but I think the trust would be satisfied if it could see at least some examples from which it could take confidence about the way in which accommodation works is going to be handled. The standard of fencing that's sufficient for livestock, things such as drainage will be taken care of, and the like. This is a working business, sir. That's really the point I'm making, And so it's back to the argument about backloading. I think this can be backloaded in a way perhaps that temporary possession cannot, but we still need to just see some examples of what's being proposed here. And I rather suspect this aspect of the objection could go away, sir.
Okay, thank you, Mr McKee. Mr Sutherland?
Sorry, sir, I lost my cursor. No additional comments on that. Thank you, sir.
Okay, and Mr Hall?
So just in support of what Mr McKee is saying, and particularly for the tenant farmer, where it's absolutely essential that we have details on the fencing. We can't have stock wandering across the countryside or be without water, for instance, for welfare reasons. So we absolutely need to have this understood and pinned down.
Okay.
If it's helpful, sir, I mean, the council will look to provide examples. The council also has to have an idea of what is required when it will be implemented, because a number of these works will clearly be carried out by the contractors who are employed by the council to deliver the road's infrastructure. So there will have to be sort of forward planning on the council's part rather than backloading. It will be front-loaded. Again, the council's committed to having discussions, negotiations with the affected parties. The council's preference would be that accommodation works are put in place because those are what are required on the ground for the purposes of the businesses, rather than relying on the fallback of compensation in the event that the accommodation works aren't implemented.
Okay, thank you. I mean, the parties have indicated their hope and intention to resolve as many of these matters, but as quickly as possible by the inquiry, if possible, but possibly thereafter will require further discussion. I guess the question in my mind is, in the event that there were no agreement or not final agreement on the accommodation works, what can I in my report do in relation to that? I can't really be an arbiter as to what's the right accommodation works to be carried out. What do I contain in my report? What happens if after I write my report and accommodation works have not been finalised, they still fall to be matters of dispute? Would parties come back to me and expect me to write a further report that arbitrates for this, or after I've reported to ministers, what do ministers do? So the concern for me, I guess, is as much information as possible, as much agreement as possible. That's fine, but on the actual questions before me, let alone via these issues about payment of compensation, I'm a little bit unclear on some of the practical aspects of this. Of what I'll be expecting to write down, take evidence of, and make findings of, in relation to matters that would, if you like, by definition, have been matters that there's been a failure to reach an agreement on. So I suppose that there's a thought in my mind of how I can, in practice, address these issues. Whether, Mr. McKee, you think I should be an arbiter or an encourager of dispute resolution in this regard, if parties can't, or whether I'm in a position really where I have to write a report based on failure to agree. If that scenario arises, and we just have to take things from there. So yeah, it's just a practical thing from my point of view.
So can I,
of course.
If I can address that, sir, I don't think we're looking for you to arbitrate on the detail and extent of accommodation works. Sorry, I'm just having to cancel my phone there, sir. I do apologise. So I mean, the way I think this can be resolved is that if the council are true to the word, I'm sure they will be, and provide us with examples, and we have a sufficiency of information, then we know that can then be encapsulated, into it will be the contractor who's building it, so it will be a contractor's obligation to deliver that in the usual way. I think that's really all we're looking for. If we fall out over the accommodation works, then I suppose it becomes monetized.
Yeah,
it's as simple as that, sir.
Yeah.
I think that's the point. I don't think you can, sir, become an arbiter in relation to these matters. I think if there's a failure to agree, there's a failure to agree. And as Mr. McKee says, you would be then looking at, rather than compensation in kind, financial compensation. We would hope it wouldn't get to that stage. It's certainly not unheard of, but we would hope it wouldn't get to that stage in this particular case. The council is the local authority. It is in no mood at all not to be able to reach agreement with local businesses.
Okay, I don't know if Mr. Holmes Sutherland have anything further they want to add on this point. I think from my perspective, I mean, as I said, and as we all understand, this is a procedural hearing rather than anything else. The thing that's in my mind is fairness to the council in knowing in advance of the PLI what they need to prepare for, and what I'll be expecting to hear if agreement isn't reached. And I suspect we can't take this much further forward today, but it might actually be quite difficult if, when we get to the stage of preconditions being lodged 2 weeks ahead of an inquiry or whatever date that might be the case, to ensure that we're clear to the council, and I'm clear to the council, what I'm expected to have contained in the preconditions. And it may well be that this is an issue we would return to in June to test progress on that then. The main thing from my perspective is to the benefit of efficient use of our time, and clarity to the council of what they would be expected to address me on. And I think if we the most I can suggest, I think, is we keep monitoring this and keep in our mind what needs to be done, and if there is anything that is useful and sensible that can be tested at an inquiry, we make that clear at a point when, if the hypothesis arise that agreement can't be reached. And I suspect that's the best way forward in this just now.
It is helpful, sir. Subject, I think, to the council reserving its position on the fact if agreement hasn't been fully reached in relation to accommodation works, the council's position would still be that a discussion on accommodation works and a failure to agree them is with the remit of the inquiry.
Yeah. I mean, the question before me is the justification for the scheme.
Yes.
So that point is understood. Okay. Anything else from others on this just now? Is that as clear as we can make that meantime? Okay. The next question, I guess, moves on again from Ms Maguire, and that's the question of the two planning applications that have recently been made and the interrelationship between the policy, and I've seen the reference to the supplementary guidance submitted to the Scottish Government recently on developer contributions, and this I think, without anticipating what parties will say, I think some or all of this will turn on the particular site that's been identified. Now, just my own point of view, my own perspective, I'm assuming, tell me if I'm wrong, that the reference to a site that may well be sterilised on Avant's argument in relation to the site. This, I think, is the 19-house site that's the subject of the smaller application. I think it's described to the north of H32. I'm assuming that's the same as what was previously described as the 16-house area of land that I've seen on other plans with arrows pointing down towards it. I'm assuming it's the same site.
That is the position, sir. Yes, you're correct.
That's very helpful. I just wanted to make sure there wasn't a second site that there was an issue arising from that.
No, I think the change in numbers, sir, was because of the original plan that was put on. I think it was attached to the two objections, was an indicative plan, and what we now have is the detailed application having been lodged, which shows an increase of 3.
Sure. I'm not making a big thing of the 1619. I was just clarifying that was the same plot. Or aid infringement. That's fine. Okay, well, thank you for that clarification. And Ms Maguire, do you want to speak first of all about the developer contribution issues and funding issues?
Certainly. I mean, the council does state in its statement of case that there is funding for this project within the council's capital programme. It also states that it will seek to recover the costs of the scheme through developer contributions. The council states these things because it's required to state them. Scottish Government guidance requires that we give an indication that the scheme can be funded. The issue for you, sir, I think is really quite straightforward. The money's in the council's capital programme. The council is funding this programme. The council accepts that there may be an element of risk when it comes to recovering contributions for developers. There always is, and there's always a negotiation that goes on, but the money is in place to take this scheme forward, notwithstanding that risk. Although the council has got reasonable confidence in its planning guidance, and it will be able to recover developer contributions broadly in line with its ambitions. Just to clarify, there has been draft SPG sent to the Scottish Ministers for approval, but there is extant planning guidance in relation to DEAR specifically that deals with developer contributions, and it's my understanding after some discussions with my clients that the SPG that is currently with the Scottish Government for approval makes no discernible difference to how developer contributions will be gathered in relation to DEAR. It's an updating of the Council's policy on developer contributions across the board and not solely in relation to DEAR, but the position in DEAR remains largely the same. So a couple of things. Firstly, the approval of the new guidance and how appropriate that is, how workable it is a matter for the Scottish Ministers, but that's subject to a different statutory approval process, and it shouldn't be the case that guidance is opened up for examination during the course of this inquiry. The second point is that the level or nature of the contributions that might be required from either Site A or Site B are not within the remit of this inquiry either. Those are matters that ought to be negotiated between the developer and the council, and in the event that agreement can't be reached, there are ways of dealing with that. The Town and Country Planning Act provides, for unilateral undertakings, that type of thing. Even where agreements have been struck and we have planning obligations, there are methods whereby those can be reviewed by the Scottish ministers. So what I'm saying is this is not the forum for any discussion on the appropriateness, the workability, the effectiveness of the Council's supplementary planning guidance, and it's certainly not the forum to be discussing or trying to agree the scope of any developer contributions arising from either of the two sites in respect to which the planning applications have been lodged. As regards the planning applications themselves, they have only recently been lodged and validated. My understanding is that the Council is in discussions with the developer as it requires additional information in relation to both applications before it can take a view on whether or not either of the applications might be consentable. It would not be normal practice for the local authority to start to engage in meaningful discussions on developer contributions before it had carried out that initial assessment in respect of a planning application. There may be a point at which the Council and the developers do engage in discussions about developer contributions, but that will be in the context of planning authority to applicant rather than an acquiring authority and landowners in the course of a compulsory purchase process.
Okay, thank you. And go next to Mr. Sutherland.
Thank you, sir. If I can possibly just repeat a point I made earlier, which is the basis upon which Avant is objecting to this order, and the basis on which it's objecting, the reasons for its objection are contained in its statement of case, and it's not looking to go beyond that. And I'm sure Mr. McKee will have more to say about the objections that may be made and pursued at inquiry. But I do want to just say that as a precursor to giving some comfort to the Council in terms of the issues that we intend to raise at inquiry, and that we are not looking to conflate the planning process in relation to the applications that have been submitted with the confirmation of the compulsory purchase order, and indeed the issues that need to be discussed and considered at inquiry. So we're certainly not looking to do that. It's not in our interest, it's not in the Council's interest, it's not in your interest, sir, so we're not looking to do that. However, that said, there's been a lot said in the course of this meeting about discussions that are taking place and about the attempts that parties are pursuing to try and actually reduce down the issues and to reach agreement, and potentially which could result in the withdrawal of objections. And the matters that need to be discussed in those voluntary discussions inevitably do go beyond the scope of those issues that are properly just required to be discussed at the inquiry. So I don't want to try and confuse matters here. I want to try and bring a little bit of clarity, because what we're trying to do just now is actually just identify what are the issues we need to take forward in this process. But and I completely understand what the Council's position is in that regard. However, there has to be a degree of acceptance from the Council that these issues, they necessarily are related for the purpose of actually the discussions that are taking place in the background. So to that extent, Avant is trying to encourage, and indeed does ask the Council, if it is pursuing a particularly strict line in terms of demarcation of issues for the inquiry, that's one thing. But on the other hand, it shouldn't hold the same line in terms of the voluntary discussions that are taking place in the background, because the reality is that these matters are highly relevant for those discussions.
Okay, thank you. Mr. McKee?
Yes, sir, thank you. That was elegantly put by Mr. Sutherland. I suppose there was really 2 points. The Council came in saying that we were raising this matter de novo. This is about the funding for the DEA, and the point I was simply making was that it was the Council who first raised the issue of the funding for DEA, and we've heard their explanation that that's what guidance requires them to do. So I'm not criticising them for it, but the fact that it's in their statement of case, it's been responded to in the letters, it is a live issue in as much as they have made it a live issue before you, sir. I don't see the role of this hearing or inquiry is to in any way examine the legitimacy of the developer contributions and the most recent SG that's gone to ministers for approval towards adoption. I think all I was seeking in my objection under this heading was really to ask the council to explain with more precision than they have done to date how they will calculate the contributions. And that does indeed lead to a broader discussion with the council, sir. If we received a commitment from the council that such discussions can be ongoing, I'm pretty confident this matter can go away, sir. You know.
And Mr. Hall. So I saw you having a well-earned glass of orange juice there when I brought you in. Apologies.
I have no comment on this subject, sir.
Okay.
Yeah.
I've just taken on board what has been said. I cannot commit to how far the council will go in terms of negotiating on developer contributions in respect of the 2 planning applications that have been received. It's too early at that point to give any kind of commitment to as and when that might happen. But the point does remain that, with all due respect to your position, sir, you're not in a position to comment on what would be an appropriate level of developer contribution for either of these applications. And I think it would be dangerous territory for the inquiry to stray into. If developer contributions have to be negotiated, they will be negotiated with reference to whichever SPG is in place at the point of negotiations. Beyond that, the council is not in a position to say anything. And I would just re-emphasise that any discussion about developer contributions, the mechanics of it, and the level of contributions will be taken forward by the council wearing its hat as planning authority. And we can't conflate the issues about the levels of developer contributions in the acquisition of the land. In respect to the planning applications, it would appear from Avant's statement of case that they do wish to address you on the suitability of the alternative access. And once again, all we would say on that is a matter for the council as planning authority to determine. It would matter not whether you had a view on that matter, sir. It's for the council to take that decision as planning authority as to whether that alternative access is consentable in terms of the planning regime. It's not a matter for the inquiry.
Okay, thank you.
Sir, yes. Can I maybe address you, sir? Yes, because I was only really addressing the issue of the funding, and Jackie has moved on to I think the heading was technical information, which was about the suitability or otherwise of the access for the 19 plots.
Apologies, Alistair. I was really responding to Mr. Sutherland's point.
Okay, sure. Okay, right. I understood. The trust are not seeking to conflate the 2 planning applications and the CPO process. However, there is a touching point there, sir, which is relevant for the purposes of the CPO assessment. And that concerns the 19 plots. And we know there's been a valid and validated application lodged for that, which demonstrates direct access from Deer. Now, I'm making no comment about the council's view on that, and I know historically there is evidence that they're saying they're hostile to that. But nevertheless, the overriding purpose of DEAR, the scheme underpinning it, is to, in part, enable access to MyDub2, of which the area, we call it Site B for the 19 plots, forms part. So the very reason DEAR's coming forward is to release land which is part of MyDub2. Now, if it's not doing that because it doesn't provide a suitable access, then that's something which I think, sir, is directly relevant to your assessment, because you're looking at the technical issue of the design of the road, perhaps, which is a separate matter from the assessment of the planning application for it. So I do think in this instance that it's a very relevant matter, sir.
Thank you, Ms. Maguire. I appreciate you responding to Mr. Sutherland's question when you spoke about that. On that question of the access to the site and the technical matters of that, is there anything you wanted further to say about that?
The council has no objection at all to the objectors if they're wishing to lead evidence on whether or not the access from the southern part of H32 into the northern part of it is viable by means of crossing the Denny Burn. The council's very interested in those questions in relation to the planning application, but the matter remains that it's not for this inquiry to determine whether or not the alternative access is consentable. That is a matter for the council as planning authority, and that would be the case whether or not the access over the Denny Burn was or was not viable.
Okay. Any other parties want to speak on this point?
Yes, thank you, sir. And I'd kept my powder dry on that point because I didn't think we'd yet moved on to that particular issue.
Yeah,
but if I could maybe return the compliment to Mr. McKee for having quite eloquently put the position that what is effectively Van's position as well, that we're not looking for you to step into the shoes of the planning authority and determine whether or not the application for the 19 house scheme, including the access off the access road, should be granted. But as Mr. McKee put it, I mean, really, if we can anchor the relevance of this as an issue for inquiry, it is definitely relevant for whether or not the scheme that has been proposed does achieve the purpose of fully unlocking the development in that strategic growth area. And I agree with Mr. Maguire that perhaps the most relevant issue there is where the disagreements about whether access could or could not be taken over the Little Denny Burn. But I think it would be somewhat artificial to ignore and to decline to hear any evidence about whether or not access could be taken on the balance of probabilities off the access road, because I think that's highly relevant for the decision that you might come to, sir, or the point you might get to if you're considering, okay, well, I'm satisfied that access cannot be taken over Little Denny Burn, so what does that mean in terms of whether or not the scheme purpose is satisfied? And then if there's a possibility of access, or rather if access cannot be taken off the access road, and that may take you in a particular direction, or if you think actually there is a possibility of access being taken off the access road, then that could take you in another direction. So I think it is a matter that is definitely relevant. And again, I'll just reiterate the point that we're not trying to conflate the two processes. I understand that there'll be perhaps a bit of delicacy about how you deal with the matter, but I do think it'd be bizarre to leave it out of the examination.
Do you know, maybe a couple of further points.
Yes, Chris.
What we're concerned with here is the DER and the provision of access into allocated site H32 in the development plan. That's all you require to be satisfied on that it serves that purpose. What we're not concerned with here is the optimum access for Avant or for the trust. And I do think there is a danger in looking at the arguments for and against an access at the northern end of H32, and for the inquiry taking on, if you like, the mantle or quasi-mantle of the planning authority. It's simply not appropriate. And I don't think it is a matter of nuance or shades of grey. I just think it's wholly inappropriate that the inquiry would pursue that particular topic as part of its remit.
Okay, thank you. Mr. Hawley, anything to say any further on this issue? Okay, thank you. I'm grateful to parties because there's been quite a lot of recognition of common ground on this, and that is that there are things that my report will not cover, and a recognition that there's no intention to stand in the shoes of the planning authority in its functions under the planning legislation in determining the planning applications that have recently been submitted. But it's also, I think, the case, as I've mentioned already, that it's not my role to comment on the appropriateness of policies and developer contributions, nor to engage again in discussions around negotiations. In some ways, echoing the point about accommodation works, about what precisely would be my role in practice, even if it were appropriate to become involved in this. I think it's right to say, Mr. Guar's right to say, that the starting point for me is the justification for the scheme, and the basis in which this fits within that wider planning context is for the council to reach a decision on. I'm conscious also that powers being taken are Roads Act powers, and the principal purpose is obviously in relation to a road scheme. There are other CPO powers that might have been available under planning, but it's a road scheme that we're proceeding on. That said, I too, in looking at this and listening to what parties have said today, there's aspects of the interrelationship between the allocation of the land for housing purposes and the planning permission process as has gone thus far, which I think it's legitimate to raise and legitimate for me to hear evidence on and address in the inquiry. I'm trying to be careful here not to either get too far ahead of myself or to make too generalised statements, but I'm conscious that the order was promoted at a certain date on the basis of a certain understanding of what the planning and other position was at that date, which, as I understand it, was that the site had been allocated for housing, and I think it's the case of planning permission in principle had been granted, but the detail came later. Now, it's obviously, I'm not saying that there can never be a change of circumstances that would come later that might change things, but I'm interested in the first place in the state of knowledge of the council when it promoted the scheme, and where the position was in relation to the ability to access what the 19 houses site was at that particular point. And my understanding from reading the papers is there was some discussion about whether access could be taken through other means. To me, there's an issue as to whether the council's justification for the order was supported by their understanding of the position at that particular time. So I think there's something to be said, and I know parties might disagree over some of the practicalities of the access over the burn, but I have to start from the point of the understanding of the council's position when it promoted the order. I can't work on the basis of an understanding that's now been made clearer, and it's, the timings are just the timings of a planning of two planning applications made at the start of this month. So I think it would be interesting to get an understanding as part of the justification for the scheme as to effectively the reasonableness of the council's position in deciding what it did in promoting the scheme at the start. So that's a question, I think, for the PLI, for the council. The question, and I don't need answers to these now because this is risk of getting ahead of ourselves. The question, I think, for the objectors, in particular for Avant and for the trust, which I don't know because I've not looked at the planning applications that have just been received and are not for me to decide, is for the 19 units, whether the planning application was made on the basis of the CPO as promoted, which they obviously know the terms of, in other words, the road layout as it is, or whether the application was made on the basis of a layout as they would like it, if that was to provide an alternative access. And if it's on the basis of what they would have liked, that's why they proceeded on that basis, given standing their objections. The preferred route, the preferred scheme of the council is the one that was advertised. So it's issues around that I think I'm interested in. I don't think answers to those questions need me to tread into areas that are not for me or developer contributions, or for intruding on the jurisdiction of the council on deciding the planning matters and planning applications themselves. But it's kind of exploring that, I think I'd find quite useful in just sort of getting a better feel than I have for right now as to the state of mind of the parties. As I say, Falkirk Council promoted the CPO, and they only knew what they knew at that particular point. So I guess that's where I'm coming from. I don't know if parties have any thoughts on that, or if that's useful in giving an indication of what might be useful to explore in recognitions and at the inquiry itself. Starting with Ms Maguire.
I think the council could give some further thought to that. I'm not entirely sure that the council does know anything more than it did know when it was promoting the compulsory purchase order, for the reasons I've outlined. You know, the applications have only just been received. The council has already indicated to me that it's looking for additional information before it can take a view on the applications. So whether or not, you know, it is informed of other things, I think it's not possible to say at this particular point in time. You know, this is one of the dangers going into this territory. There's already, you know, some suggestion we have 2 sites here. Well, there may be 2 planning applications, but the jury is still out on how the council is viewing that, as whether it's, you know, subdividing one site or whether we can legitimately be looking at 2 separate sites. I'm not in a position to comment on that at all because I have no information about the council's position. But, you know, anyone can see we have a single allocated site in the development plan, and the council may have concerns if it's subdivided. So that's the kind of territory we are getting into here. But it may well be that this is something that has to be taken away from the meeting today, and maybe some further submissions or some further points of view submitted to you, sir.
Yeah. Okay. I'll just say, actually, I'm also not placing too much significance of the fact that it's one planning application and 2 applications. I understand that point, but I can also I think I can understand why 2 applications are made, but that's a process issue rather than a matter of substance, I think. Okay, Mr. Sutherland.
Thank you, sir. Your views and comments on where you see the issue lying in relation to this is certainly very helpful, and I'd agree with Ms Maguire that I think there isn't. I think the second CPO coming forward in a further business meeting a couple of months' time actually does give us an opportunity to try and focus the questions that we'd be asking you to consider in relation to this issue. I mean, it strikes me that if we're actually trying to knock this out as an issue just now, and I think you've already said, sir, that that's not your intention, that there's almost, I mean, it's almost a bit like a kind of proof before answer point here. You know, you kind of need to hear the evidence on the matter before you can actually see what are the issues that you need to actually address in your report. And I think trying to really kind of crystallize what those questions are and what the issues are very precisely before hearing the evidence on this, I think would be quite difficult. But I think what we should do is try our best to do that between now and the next business meeting.
Yeah, thank you, Mr. Mickey.
Yes, sir. I'd like to be associated with Mr. Sutherland's comments. I remain of the view that it's relevant, but I do understand your analysis of it, sir, on the basis of you need to know who knew what and when, and it's a bit like your proof before answer. You need the factual basis and the timings before you can opine on this further, and that is hopefully something we can make some progress on between now and the business meeting in June.
Okay, perhaps just to raise a remark on the council's behalf, we prefer not to get
Absolutely.
into proof before answer territory. The rules don't provide for it.
Sorry, I was just going to ask if Mr. Hall wanted to say anything further before we give you final word. I beg your pardon. He's saying no, so the floor is back to yours. Yes, you don't want to get to before answer territory.
No, we don't want to get to before answer territory. We don't want to waste time and energy, money, all the rest of it, lengthening the proceedings unnecessarily. What I think is more appropriate, and I do appreciate there maybe have to be some further discussion on this, is that the scope of the inquiry and the issues to be considered at the inquiry are clearly defined at the outset.
Yes. Yeah. Okay, thank you. That's very helpful. Is there anything else arising? I think we've probably covered everything from the Falkirk Council's letter of 18th March. I think we conflated the last 2 together in one wider discussion. I think we'll probably cover everything really from that perspective. As I say, I think I'm not willing to rule the objection out on the basis of this discussion, but that we get greater clarity in the period ahead and return to this when matters are a bit clearer when we meet again at the end of June. If that's the case, item 6 is the appropriate form of the PLI and stroke hearing. And now this, I think that to a certain extent, this has become perhaps a little bit of a redundant question. I was going to seek views on the interrelationship between a public local inquiry stroke hearing and the lifting of COVID restrictions. But if we're now going to be in a position where we're looking to be having something in the autumn, then that hopefully will be less of an issue now. Fingers crossed. I never thought I'd ever hear myself saying that I'd be delighted to be in a room with you all having a public inquiry, old school style. But actually, wouldn't it be wonderful if we can get through and get to the end of this appalling year that we've had and be able to do something of that sort of nature? But I don't think we need to make a sort of a decision about a face-to-face inquiry as opposed to anything virtual at this stage, and I hope by the autumn we'll be able to do so. And if we can do so, my kind of instinctive feeling is that hopefully being the case, doing this by a PLI with opportunities, if that proves necessary, of cross-examination and the like, is probably the best way forward, rather than going along lines of a hearing. We'll talk in a minute about the extent to which we can maybe focus on the issues that we can discuss. But on that point, I very much invite views as to what parties' preference is for hearing this. I'm conscious there's a presumption in favour of full PLI for a CPO because of the A1P1 rights and the like that are involved in this. But first of all, the council, do you have any thoughts or views on the format of how we proceed?
Yeah, well, the council's preference would be for a hearing if that was something that other parties be agreeable to. We've dealt with Mr. Jack already, and we'll deal with him by way of written submissions. Looking at the matters that are on the table, I know this may sound tricky given the conversation we've had thus far, but we do think that the scope of further oral procedure is likely to have a fairly narrow focus. And given that, we wonder if it is a good use of time and money to embark on a full PLI process. I mean, my experience, a hearing can give more than adequate opportunity for questions to be put to witnesses, for clarification on the issues to arise, and for you yourself as a reporter to gain a good insight into what the issues are and what the parties' positions are, and to see the evidence tested adequately. If, however, you were inclined to move to a full inquiry for any aspect of the objector submissions, then I think it would be useful if we could put some time and effort in early doors to looking at what can be agreed and perhaps have an agreed statement of facts. So, for example, if we're taking forward technical evidence on roads issues, it would be useful, I think, if the parties could agree what were the standards in place. What are the standards in place at this particular time? If there are things that are not in dispute, if we could provide a list of those so that we're curtailing the evidence that has to be laid on those points and only focusing on the issues that are in dispute. I mean, I do think that a hearing has an attraction because I do think personally it's a more efficient and effective way of dealing with it. There's quite a lot of palaver and procedural context to a full-blown inquiry, which can take up quite a lot of time and effort, and ultimately we don't refer to many of the documents etc that are actually submitted and all the rest of it. So preference would be for a hearing, but if you were of a mind to have an inquiry, for example, into the technical roads evidence, then I think it would be useful if the parties could try and agree as many issues up front as possible.
Thank you. I mean, that's something I was going to come on to, actually, because I think, it's very useful for the council to have given in their statement of case a very full indication, both of duration, but also content. But whatever we decide to do, there's a lot to be said for trying to narrow issues. And Mr. McKee at the very top of the meeting indicated that other objectors agreed that the principle of the road is not something that's being objected to. And I think that there must be a significant scope on some of the areas to reduce the need to be hearing evidence and taking anything, certainly by way of cross-examination. But I'm going to see Mr. McKee first of all on this issue.
Thank you, sir. And you'll be delighted to hear, I hope, that I agree with much of what Jackie Maguire has just said. I think this case probably is more meritorious of a hearing method rather than an inquiry. The only aspect where perhaps evidence might need to be tested is in relation to the direct access or not of deer. In that regard, I mean, I would say perhaps that does lend itself to an inquiry. But I suppose overall, I don't think we're pushing for an inquiry. We would be content for matters to be dealt with by way of hearing and submissions. And yes, absolutely, we will try and agree matters as much as we possibly can. Caveated with my first comment is we want to get this resolved, sir, so that does not happen. So with that's my position, sir, or the position of the trust.
Okay, I'm grateful for that, Mr. Sutherland.
Thank you, sir. Avant had, in its statement of case, proposed an inquiry session for the evidence from transport consultants, but I mean, that was probably a default statement that would be the kind of the ordinary course of events. And actually, I'm probably in agreement with Mr. McKee and Ms. Maguire that it's the scope of the matters that are likely to be in dispute should be fairly narrow, and actually, even from a technical complexity point of view, wouldn't expect the matters that are in dispute to be particularly complicated. So on that basis, it probably, I think, not probably, I would suggest that a hearing session would be more efficient, and certainly where we're all pushing in the same direction of trying to get this resolved as quickly as possible, a hearing session would minimise the delay. So we certainly wouldn't stand in the way of a hearing session if that was the preferred forum.
Okay, thank you. Mr. Hall?
Thank you, sir. Very much in agreement with the other parties. Hearing would be the way forward for us.
Okay, well, I'm grateful for that. I mean, the main points I take from that really are the kind of this technical issue about whether, because this is a CPO, there's an entitlement to a full PLI. But given that the objectives have indicated, with certain caveats, that they're willing to recognise that a hearing might be the most efficient and effective way to address this, that sounds like a kind of working assumption, that we can proceed and take forward going forward at this stage. Like Mr. McKee, when I was thinking about this, I tend to think that if there is going to be a need for any cross-examination, it's probably around that question of kind of understandings around the access road and the like. So there may be a narrow need to be looking at those sort of issues. But I too would endorse the idea that in the period ahead, the more scope we have to narrow the focus of the issues, the better. And as I say, I was very grateful for Falkirk Council's very full indication of the topics that they would potentially cover in precognitions and documentation. It may well be that scheme design, the road safety and other issues of that sort of nature don't really need to be addressed in any more detail. There might be a little bit more on justification of benefits, but even then, that's maybe a maybe rather than anything else. Land take, yes, obviously air quality for Mr. Jack. So there's a small extent of which I think things might require a little bit more formality, but certainly for my part, with the caveat stated, it would seem to me that all of that could be accommodated within a hearing process.
I think that's correct, sir. And we will revisit the witness list. It was drafted at a time when we weren't sure where things might end up.
Of course.
But on matters like air quality, having agreed that those can be dealt with by written submissions, clearly we will revisit the witness list. There wouldn't be any requirement for any oral evidence in relation to those matters.
Yeah. Okay, that's helpful. So we'll continue to keep that under review, and obviously the kind of the fixing of matters in terms of times and dates and local arrangements are for the next meeting or beyond, to find dates that are as far as possible convenient to all parties. And I think I'm grateful to the council but also Avent and the Trust. I know Mr. Hall still looking at this, further indications of how long they would expect to need for this, but I'm also conscious that certainly the Falkirk Council indication was on the basis of what the position they understood when they submitted the statement of case, as opposed to where we get to. So the 3 days they indicated will hopefully be able to be cut down to a fairly significant extent. So that's helpful from that perspective.
Just one further point, just to be helpful to Mr. Hall. I appreciate that that there's a suggestion that a statement of case will be submitted on behalf of his client. I don't think the council would have too much difficulty with the notion that if Mr. Hall wished to hold that over until he had seen the second compulsory purchase order, I think the council would be quite satisfied to have any objection or any statement of case submitted and to be applied to this order in the way that it would the second order. I'm just conscious of the fact that he may put a lot of time and effort in at this particular point and only have to duplicate it in a short period in the future.
Yeah, I think Mr. Hall's nodding at that point. Yeah. That's a very valid point. I mean, I understanding and sympathising with the difficulties of communication that have been with this firm, and it's placed him in a position where he's had to come to this meeting with maybe less notice than he otherwise would have done. I was fairly deliberately not saying to him, you've got a deadline of X days to produce your statement of case, because I recognise the challenges for him. But that point about waiting to see the second scope of the second CPO, simply because of the extensive degree to which the issues relate to Plot 2, I think is a very fair offer, and I'm sure Mr. Hall will gratefully accede to that latitude to have a little bit longer. But obviously, as soon as he can reasonably produce a statement of case after he's seen the second CPO, that would be enormously helpful.
That's appreciated from my part. Yeah, thank you.
Okay. The other thing that I don't think we really need to talk about this now, because we're not going to be looking at a hearing until the autumn. But two things I'd mention. We'll talk about the detail of how the hearing works at a later point. I am inclined, when it comes, as all lawyers are interested in these things, to be looking at closing submissions to be submitted at a date after the hearing, not at the end of the hearing, just to give you fair warning that I won't be expecting you to stand up at the end of the hearing and give eloquent summations of your case. The exact period and how the detail of that works, we can work at a later time. But that's my kind of inclination at this stage, so you can plan on that basis. The other thing, which does relate to COVID to a certain extent, is a question of a site visit. For Ms. Maguire, I will probably, as soon as I'm really permitted to go unaccompanied to various places, will probably take a look. It'll probably be actually after 26th of April with the time limits to have an unaccompanied site visit, and I can certainly go through Deer 1 to the end to look at that. I don't know how the topography of the farmland is beyond that for me if I was on my own to be able to look for any further beyond that, or whether I would need to be guided or supported. Obviously, the consent of landowners given for me to see beyond that. If you have any, I don't know the Denny area particularly well, so if there's anything I need to know about for going on an unaccompanied site visit, if it comes to a hearing in the autumn, and it may well be by that stage we can have an accompanied site visit as part of the hearing process, but we can worry about that a little bit later. But if there's anything that I need to any consents I need to get, or if someone tells me it's just not possible to walk over the farmland or farm tracks, then I'll bear that in mind when I think about an unaccompanied site visit.
So if I could just say that I'll take instructions on that point from the trust itself, and I'll liaise with Martin Hall as well, sir, so that you'll be made welcome and safe.
Thank you.
If it's of assistance, I've been involved in a hearing process recently where the acquiring authority, produced a map with certain suggestions about where access points might be taken, where it's good to park, etc. And invited them to report. Ultimately, it's up to you if you want to take advantage of that. But if you don't know the area, at least it gives you an indication of where you can park, how long it would take you to walk from point A to B, so that you can plan your time out usefully.
No, that'd be useful. Thank you. Okay, right. I'm conscious we're 4 minutes ahead of our due end time, which is kind of extraordinary. I'm looking through my list of various questions. I'm not sure that I've anything more to raise from my perspective. I think this has been recorded, so you can come back and look at it later on. But my intention is to provide a brief note of this meeting so far as relevant to guide parties going forward. I've been scribbling notes as I've gone, and I will circulate that for any comments as to accuracy just as soon as I'm able. Obviously, there'll be some time into next week. But I don't know if anybody has anything further that we want to raise at this stage to assist us taking things forward.
Okay, just check with my clients if they have anything.
Nothing from me. Nothing from me, Jackie.
Thank you.
Okay, in that case, if there's nothing else, I'll thank you all for your assistance and support this morning. I found that very helpful in clearing matters up from getting things clearer from my perspective. And we'll meet again in 2 or 3 months and see how we're progressing with the St. CPO. So I'll just bring the meeting now to an end.
Thank you.
Thank you, sir.
Thank you. Cheers.
Thank you. Thank you, sir.